I have a wonderful treat for you all today. You're going to love this because, as you all know, on this channel, we have been investing in exotic currencies such as the Iraqi dinar, the Venezuelan bolivar, the Vietnamese dong, what else? The Indonesian rupee, the Indian rupee, or Indonesian rupiah, and so many other currencies, including the Zimbabwean zim bond. So when you have assets like that, as well as precious metals, silver and gold and copper and other precious metals like palladium and platinum, you need to put those into some type of device or some type of avenue that where it is protected. So we've been talking about that a little bit, but today I have on a great friend who is a professional. He has been doing this for a while for a living. He has clients that range from professional athletes to businessmen, real estate investors, some of which I know. And so I'm telling you, he's good at what he does, phenomenal. And he has a staff that is excellent, family, and it's a family-owned business. Now, you know how we feel about that. Family-owned businesses are very important as we go into a whole new reality, family. So as well, some of you realize that with NESARA and GESARA, we're going to have trillions of dollars ejected into the economy, some of which will go into your quantum accounts, as much as $100,000 a month into your account up to 10 or 11 years in a non-interest bearing account. So you don't want to become wealthy and not protect your assets, because everybody on the planet has not risen to the state of consciousness that we have. So some people might be out to try to take your assets. But don't worry about that if you don't have any of that yet. Some of you have a home, you have a car, you have a business, and all those things that need to be protected. So what I did for you today, family, you're welcome, is bring on a good friend of mine, attorney Scott Hall of Skrajovan Trust, to explain to us why we need to protect our assets and how we can do that. So without saying any further ado, family, I introduce to you attorney Scott Hall, and I yield the floor to this professional to speak to us about estate planning. It's on you now.
Good morning. I'm not sure what time of day this would be on, but again, my name is Scott Hall, and I specialize in estate and trust planning. We understand that for so many of us for so long, we have been raised by family members that have lived by the will. And then for so many of us, we've done nothing. We've just assumed that, God forbid, when something happened or when that time comes, my wife, my spouse, my eldest son or daughter may do the right thing. The estate planning process is a very simple process. It sounds large, big, and cumbersome. It sounds intimidating. And for many of us, we believe that estate planning is for the rich, the well-to-do, the sophisticated. Not so. It behooves all of us to put our affairs in order. And simply put, estate planning is nothing more than putting your affairs in order. Who gets what? And it gives you insurance or assurance in knowing that when you put your estate plan in place, and the foundation of your estate plan should be a trust, nothing less. The foundation of your estate plan should be a trust. So when you put that trust in place, you can rest assured that who you desire to receive your assets will. Okay, there's no iffies here. We're not relying on the probate system, the probate process. We're not relying on lawyers and judges. Okay, so simply put, understand, that's all it is. The estate plan is nothing more than putting your affairs in order.
Okay.
On you, Ms. Kia.
Okay, so when you put your affairs in order, you think of having a will. But I don't know the difference between a will and other avenues or other methods of protecting your assets. Can you give us an explanation of how we can put our affairs in order?
Well, let's understand this. You got to understand, first of all, the difference between a will and a trust.
Okay.
For so long, our grandparents, granduncles, great granduncles have all talked about having a will.
Yes.
And for so long, what they've said also, once the will has been drafted, properly signed and executed, you're going to hear the next thing is, my will is with my pastor, is with my lawyer, or is with my oldest child.
Okay.
Understand this, though. The will is truly, truly a dead document. It does not become alive unless there's a loss. Okay? A will is a document that expresses one's wishes only. It transfers nothing legally. The will transfers nothing legally, folks. Yes, I said it. It transfers nothing legally. When you leave your assets in a trust, in a will, and you want those assets to go to your loved ones and your children or your friends, whomever, you're asking the courts to make the final decision as to what happens to your asset, what happens to your stuff. Okay? So a will is better than doing nothing, but it's not what you want when putting an estate plan in place.
Okay. So can you clarify, okay, what exactly is an estate plan and who should do it? Do you have to be rich to have an estate plan in place?
Well, an estate plan is basically pen and paper,
Okay.
and going to a professional that can put some legal language to it to legitimize your document, what you want to happen to your stuff upon your death.
Okay.
Lawyers can do it. Estate planning professionals, preferably those with credentials. The estate plan, the misnomer is the estate plan is for the wealthy, the well-to-do, the sophisticated. As a matter of fact, many of them die every day without anything in place. And of course, we know that's called, without a will or trust in place, that's called dying intestate. It doesn't mean that the state will get your stuff. It means the state in which you have passed, there was nothing in place. So truly now the burden, everything rests upon the courts. Okay? The estate plan, again, allows for a smooth transition when its foundation is a trust. It allows for a smooth transition and the distribution of your assets upon your death. Okay? The estate plan also gives you some protection during your lifetime. The estate plan, the trust, which we preach as the foundation of the estate plan, benefits you today and it perpetuates your legacy in the future.
So I took your class and I recall you saying that, and you can correct me if I'm wrong, that a trust is a living document that holds and manages your assets. Is that correct?
That's correct, but I would add something to
Okay.
that. So yes, the trust is a living document. It is a legal document
Legal
that
document.
holds and manages assets.
Okay.
It is the relationship between the grantor of the trust and the trustee. Keep in mind, when most individuals put a trust in place, that's the foundation of their estate plan, they are the trustee of the trust during their lifetime.
Okay.
In addition, they are also the beneficiary of the trust during their lifetime. So if it's a couple, a husband and a wife, the husband and the wife will be the grantors of the trust. That's the person having the trust made.
Okay.
They will be either he or she, or either party can be the trustee of the trust, and they both will be the beneficiary of the trust.
Okay.
Now, upon your death, there's language in the trust in which your loved ones, your children, friends, family members, they would be the contingency beneficiaries. They're contingent upon death or upon your passing of the last spouse, or however you want to have the language stipulated in the trust as to when and how the assets will be distributed. Okay? But you're certainly in control during your lifetime.
Okay. And I recall you saying that there is a distinct difference between a trust and a will, in that the will, you will have to go through probate. And when you go through probate, I believe it's the judge or the courts that will determine how your assets are distributed. That's right, correct?
Yeah, now the probate process, it's expensive.
Okay.
It is lengthy. In my opinion, it tarnishes relationships. People are destroyed after probate, family members. they stop speaking to one another. I have clients that haven't spoken to brothers or sister in 30 years
Wow.
because one feel like I was done wrong. I was taken advantage of. When you leave your family in that type of situation, there's nothing good about it. In my opinion, there's nothing good about putting a will in place. Okay? Now, some may beg to differ. Now, unless you're putting a will in place that may serve as a pour over for assets that's not located to be added to the trust at some point in the future, that's fine. Or after the probate, the assets go into the trust through a pour over will. That's another scenario.
Okay.
But the will, of course, has to be probated. And I'll give you an idea of how the probate process works.
Okay.
Okay, so you hire, somebody dies, and I'm going to make this one a little simple.
Okay.
Somebody dies with a will in place. They have someone in the will that they chose to be the personal representative. In the state of Florida, which is where we are,
Yes.
we use personal representative. Some states still use executor or executrix. Now, you hire an attorney that goes to court to probate the estate. The attorney opens the case with the judge, and he explains to the judge that, Your Honor, I'm not gonna serve as the personal representative. I'm only gonna be the lawyer. Mr. Johnson, oldest son, is going to be the personal representative. All the family members agree with that. That's all fine. The judge then admonishes the personal representative or through the lawyer that I need Junior to go out and marshal the assets, find the assets, take inventory. Let's get an idea of what this estate is worth. Okay. Now I'm giving you a smooth scenario. So now that's all going along.
Right.
Within 2 months, Mr. Johnson has found all the assets, and he reports back to his attorney, who then reports to the judge. You also have a scenario where the judge is going to admonish the lawyer, which he knows this. He's got to advertise in the legal section of the newspaper in the county that the decedent has lived in, reside in for the last 6 months. And that gives creditors, anyone who feel like, hey, I'm owed something, to file a claim against that estate. Okay. Now, based on the calendar of the courts, if there are no claims filed against that estate, no one's fighting, then you may have a year and a half before things are over with.
Okay.
That's a long process now, but in the process, though, there are fees that incurred. The average case in my area, if somebody dies with a home that's worth about, say, $200,000, and a couple of cars, an investment account, a little bit of savings, you would pay at least $5,500 to probate that estate. Now, if you're fighting and there's caveats and motion after motion, the longer the process lasts, then of course the fees increase. So that's a smooth scenario. Now, if you have a scenario where there are children from previous relationships, blended families and things like that, everyone shows up to court with their lawyer. Everyone has representation. That's a dogfight. It's expensive, and it's going to be lengthy. We're talking years. That's the probate process.
Okay. And then when people contest it, then where do those fees come from? Do they pay those fees themselves?
Well, now, in some cases, most counselors, most lawyers they're going to collect a retainer up front. It may be what they charge to probate their case, and they'll bill you according to the hours that would exceed the retainer. If an individual says, well, I only have a few $1,000s, say I only have $3,000,
Yes.
the lawyer tells you his fees is $8,500. But the lawyer looks at the probate and realizes, okay, there's some savings account it's going to go to the estate. There's some investment that's going to go to the estate of the decedent. There's some assets. The lawyer may feel comfortable knowing that, okay, I can go ahead and work. I'm going to get paid.
Okay.
So, but those fees reduce your benefit. For those of you that's watching this video, what you stand to inherit is going to be reduced because the cost is going to come out of the assets, whatever's left to be divided among the heirs, the beneficiaries.
So if I understand you correctly, you're saying if you have a will in place, it must go through the probate process, which is a court. And so when that happens, it can be a lengthy process. People can contest it. It doesn't, just because you have a will doesn't mean that the assets will be divided the way you think they should. And when people contest it, those fees come out of the estate.
Absolutely. So keep in mind, I think for most individuals, especially individuals who look like us, because we've been the ones slighted for many years. Okay. Um, a will only expresses your wishes.
Okay.
That's it.
That's
It
good.
transfers nothing legally.
Mm,
If I've worked hard 30, 40, 50 years and I have amassed some stuff, some assets,
yes.
I don't want another man deciding who should get my assets.
Mm,
Okay. I can do that while I'm alive. I can put my estate plan in place while I'm alive, with the general premise being that the trust is the foundation of the estate plan. Okay. That gives me assurance that knowing that who I want to receive my gun collection, my wedding band, my collection of cars, property. I'm certain that who's in the trust to receive those assets will receive them unless they predecede me. Um, and then, of course, I'm still alive, so I'll make changes. Um, the will has to be probated.
okay.
The will transfers nothing.
Mm,
It has to be probated.
okay.
Now, in the probate process, individuals may contest. For example, I've got 5 sons, okay, and I've got 2 daughters. I've got some cousins. Now, I want most of my assets to go to my children, but I have some guns that I want to give to one of my nephews,
Okay.
and it's in the will. Now, individuals may begin to question that. They may challenge that. Even though it may happen, they'll challenge that. Understand, too, let me back up for a second. The first thing that happens in the probate process is to determine whether or not the will is legal, the authentication of the will.
Okay.
Okay? Because we know when an individual dies, wills just start popping up. Like they grow on trees, they pop up from everywhere.
Yeah.
Individuals are trying to be, number one, in the first position to receive the assets. So you have instances where you may have a will with legitimate signatures of the decedents, okay? But there can be a question as to timing. The will might have been signed when the decedents were incompetent. They were not in their right mind. So these things has to be examined and sorted out. And so that just, the fight begins at that point.
Yes.
Because if a will is deemed not a legal document, not a legitimate will, it's set aside, it's tossed out. Therefore, now the person have died intestate because we cannot find a will.
Mm,
I'm not going to rely on that, period. And now I know better, so of course I will do better. Now you're getting some of this information, you now need to do better. Or you need to start doing some research and reaching out to individuals to get a better understanding and an explanation of what should happen when you begin to put your estate plan in place.
okay. What I really like about the trust versus the will is that the trust allows you to do something outside of the system. It allows you to operate as a sovereign being. And I always talk about how we're sovereign. We can take control of our own lives and take control of our assets. So I love this idea of operating outside of the system. Having said that, I'm wondering, once you sign the trust, so the trust, I guess you list all your assets, yes, in the
Yes.
trust, in this living document, then you sign it as the grantor, and then you have a notary to notarize
Well,
it.
what happens is the individuals having the trust made, they are either called the grantor, the trustor, or the maker.
Okay,
They all mean the same thing. They use interchangeably based on which industry you're doing business. We know banks like to use trustor, the financial industry, and the legal industry, we like to use the grantor or the maker.
okay,
Once it's signed by the grantors, the trustees, it requires two witnesses and a notary to
Okay.
be a legal document. The grantor, two witnesses, and a notary.
Okay. And then do you record it somewhere, the trust?
The
Or do you,
trust itself is not recorded, but at our firm, what we do, when an individual's come in to put an estate plan in place, and we're using a trust, we certain things that would allow the government to know that you have a trust.
okay.
Okay, if you want them to. So we apply for an EIN number. That EIN number identifies your trust as a separate and legal entity. The EIN number also allows the trust to open its individual accounts, investment accounts, business accounts, bank accounts.
Okay.
Okay. Now, assets are recorded in the trust and are recorded certain places. For example, if you have land, if you have property, you have a house. When we draft the documents and we do some conveyances or warranty deeds, and you transfer your home to the trust, we want to record that. So we record that at the clerk of the courts.
Oh,
Okay.
okay. I see.
But as far as taking the big document with your private and personal information,
Yes.
no, that's only for you to keep. So the trust gives you privacy. No one knows the assets you have or how they're being distributed. And that's a big deal
Yeah.
because you don't want creditors waiting in the wings for assets that your loved ones may receive. And then there's certain instruments can be put into the trust and can kind of prevent that anyway. And a spendthrift clause will prevent your loved ones from pledging their assets in the trust or their benefits to creditors and things like that, or from creditors forcing them to receive benefits from the trust to satisfy their concerns.
Okay. So you talked about transferring a house into the trust. Should I transfer should I put my house in my adult children's name?
Well, that's a bad idea all around. And now, if you just want to give them this house during your lifetime, you can give it to them. But if this is the home you plan to continue to live in, but you just feel like I want to make a smooth transition. When I die, I just want this home to go to my son.
Yeah.
It's all okay until something happens. It's just a matter of time because something is going to happen. So when I teach or when I do seminars or workshop, I teach against transferring your most precious, your most expensive, your largest asset in your adult children's name or anyone's name for that matter of fact.
Okay.
When you put your home in your son's name, who's a good son, he's married, he has a wife, they got a great relationship. You know, we live in a very litigious society. People get sued all the time.
Yeah.
Things happen. Understand, when you transfer that home into your son's name or your daughter's name, whomever, that becomes community property to the husband and wife. That is their asset. Even though you say, well, only my son, I signed it into my son's name. His wife didn't sign. God forbid, if they get a divorce, that becomes a part of the process. Okay? That becomes a part of the process. Now, the wife if she wants to be nasty about it, she can make it an issue. Well, we're not just worth $500,000. Your Honor, we also have another home that my mother-in-law lives in. That's worth another $400,000. So we're worth $900,000, and I want 50%. If you don't have cash to pay the spouse out or the buyer out, if you want to say, then you've got to liquidate. So it could be a problem. Not only that, children get sued. We drive reckless. People get in accidents. Sometimes the worth of the policy is not sufficient to cover the damages. So individuals may sue you beyond the scope of your policy. Now everything's exposed. Okay?
Okay.
I don't think it's a good idea at all to put your home in your adult children's name. Now, if there is a process by which you want to transfer your home to your adult children during your lifetime, and if you plan to move on to another facility or maybe another home, an assisted living facility, then you can. I would feel better putting it into a qualified personal residence trust, or just put it in a plain old trust.
Okay.
So, upon your death, it's going to go to them anyway. But if you think, well, I'm just going to skirt having to put this trust in place, and I'm just going to transfer it into my into my child's name. Well, you creating a problem,
Mm.
or you're setting yourself up for a problem.
So thank you for explaining that. I heard you say
Sure.
something about a qualified, what you call it, qualified personal residence trust. That made me wonder what type of trusts are there? Are there many different types of trusts that we
There
need
are
to
many
know?
different types of trusts,
Okay.
um, and in some cases, estate planning is an a la carte is going to a restaurant and chosen from the menu. When we do estate planning, we put the trust in place based on the individual situation. Okay. Now, we hear all the time individuals are battering about, oh, you need an irrevocable trust. I need an irrevocable trust.
Mhm.
I'm not saying there are times when that's not needed, but you have to understand what you're doing when you desire to put an irrevocable trust in place. Because basically, what you're doing, it's gone. You're putting the assets there, and it's over with. There's
Mm.
no taking it back out because you changed your mind. You know, I give you this $2,500 watch or this $50,000 watch, or but then you stop speaking to me, so I want to get that watch back. But I've got it in the trust for you right now.
Mm.
That's over with. Okay. When we put an estate plan in place, we use the irrevocable trust based on state taxes for the ILETs, irrevocable life insurance trust, and things like that. But a plain old living trust, a revocable trust is put in place because during your lifetime, you're going to have amendments. You'll move things in and out. You don't have to sell everything in the trust. You may have a home in the trust, and eventually you might want to take the home out and refinance it.
Mm.
Okay, to do that, then you'll do it. You can do it in your personal name if you've got the good credit. If the trust has no credit, then there may be some problems. Individuals, most financial institutions want to finance the home in your personal name. So we use the revocable trust as the foundation of the estate plan. And in some instances, when it's necessary for an irrevocable trust or an ILET, then we do that accordingly.
Okay. So there's a revocable trust and an irrevocable trust. Those are the two that we need to know about.
Correct.
Okay. Okay. Um, okay. So a lot of people on my channel are interested in a common law trust because they know just from research and from the things that I report that at some point we might move to a common law back to constitutional law. So I wondered, does your firm handle common law trusts as well as the trust that we've spoken about?
We can put a common law trust in place, but the individuals that's wanting to put a common law trust in place today, they've got to be prepared for everything once they decide to go that route.
Okay.
Because we're not there yet.
Okay. Yes. Yes.
But it doesn't mean you cannot put a common law trust in place.
I like the way you
So
said
you have to
that.
have a good.
I'm sorry.
Go ahead.
I like the way you said that we're not there yet. So we don't want to just wait until that happens to put our affairs in order now. And we don't want to move ahead of ourselves. It's important to start where we are and protect ourselves now. And then later, I'm imagining if the trust is revocable, then you can change it to a common law trust.
Absolutely.
Oh,
Absolutely.
that's so reassuring.
But I like what you said though, but because it's good to be proactive, okay?
Okay, okay.
So if some of us are moving in that direction, you can't wait until we get there.
Hmm.
Protect what you have today. Protect your stuff, your assets today.
Okay.
Listen, death's inevitable and
Hmm.
it's not timed. So
Right.
God forbid if something happened to me and I've worked hard and have a few little items, I want my loved ones to receive my items without any issues. I don't
Absolutely.
want another individual determining or deciding who should receive my assets.
Mhm.
Okay, so you got to put something in place now.
Right.
And when the time comes, if we need to make amendments, we need to make addendums, or make changes,
Mhm.
completely do away with a document and put a new structure in place. That can be done.
Scott, thank you. I've heard people say you can put a trust in place yourself, and I'm one of those people who believe in doing things yourself. But the difference is when I looked at my trust compared to people who had an attorney who's been doing this for a long time create their trust, I've noticed that I missed a whole lot of things, a whole lot of addendums that I should have added in my trust. So, what is the benefit of someone using a professional like you to create the trust? for them or with them.
You know, you always gonna have those individuals who they're the fixer upper. You know, they do the home maintenance. Uh, they may even go online and Google and do some research. And let me tell you something. When it's all said and done, don't go the cheap route. Go and pay a professional to do it. Now, if you are the professional and you're putting your own trust in place, well, good, you're qualified to do that. But I have individuals bring a trust to me, and it may be 3 pages or 4 pages, 5 pages, and they say to me, "Oh, I have my trust." And when I look at it, I'm trying to be as tactful as I can, not to speak down to them about it or not to embarrass them. Okay, you may be able to find a body of a piece of a document or a document, but that's not estate planning. When you're talking about your affairs to ensure that things are going to be done correctly, go see a professional. Okay, because you can begin the process, and you're gonna miss something. You're gonna miss something because it's not something that you do. You won't have the necessary access to the necessary information to put the proper plan in place. The average estate plan, the average trust, would comprise of probably, I would say, 70 to 80 pages. Okay,
Yes.
a real language, real document.
Yes.
Okay, the verbiage needs to be correct, and the verbiage needs to protect you. It's always good to be able to come back and say, "Listen, this gentleman did it for me. Well, this is not right. I need to get this fixed." When you mess up and you put your trust in place, and things not done correctly, now you need to go and have it looked at and have it revisited. No lawyer, no counselor, no trust advisor, no trust professional wants to make addendums to someone else's document. You're gonna have to start afresh, okay? And then the fee is the fee, okay? So you can't bring me your document and say, "Well, I didn't do this part of it. Can you put this in for me?" No, I'm sorry, I can't. I don't operate that way. I want to start from scratch. So I don't think it's a good idea unless you're in this industry and this is your profession and your experience would allow you to do this just as if you were doing it for another individual.
Well, you mentioned the fee. What if I just have a house and or a car and I want to put my assets in place. I mean, I want to protect myself. I want to get my affairs in order, but I'm thinking I'm afraid that I can't afford it. What would your answer be to somebody that said, "I can't afford it"?
Well, the fact is you can't afford it.
Okay.
You cannot afford not to do it.
Mhm.
Now, I understand that you may not have the fees in total to defray the costs, to cover the expenses. Um, you can then turn to the individuals that stand to benefit from the trust that will be distributed in the future. Your children, your loved ones. If my father needed to put a trust in place and couldn't afford to pay for the trust, but I know that I'm one of the beneficiaries, I'll find a way to pay for the trust or get the fees covered, protected, taken care of. Because
Absolutely.
it's either you pay now, pay a little now, or pay a lot later.
Mhm.
So our fees are very nominal, and I think most individuals can afford to get a trust done with our firm.
Okay.
Um, there are fees that may be a little different for some individuals, so it's to give out just a blanket cost.
Yeah.
A few $1,000s, you can put a trust in place.
Okay.
But our firm, our fees are very nominal. I can assure you that when you call, based on your situation, it is definitely affordable.
Mhm. Yeah, and I always tell people, everything is relative. It depends on how important this is to you. To somebody might think it is going to be costly, but like you said, you're going to pay in the long run. You want to pay now up front and be proactive, or do you want to pay later and have your family in flux and fighting each other because they don't know, what's going to come to them, or they don't agree with what you have put in place. Another thing I wanted to ask you is, are you able to create a trust for people that live outside of the state of Florida?
Absolutely. When you put a trust in place for individuals in other states, other domicile, other countries, well, there's certain language in the trust that will allow the trust to be governed by the laws of the state of domicile if there are issues that may arise.
Okay.
So certain I can just give you the one line answer and say yes we can, but I'm just wanting to make sense of why. I just want to qualify my statement, but yeah, we can put a trust in place in other states and countries.
Okay. Okay. Um, on the side, so I do have my YouTube channel, but I also do some life coaching. And in my sessions, I've talked to people who want to get married in the future. And so what they tell me, especially like women who are, doing very well, the boss chicks, that they got their own thing going on. They don't know about trusting a man. And then I have men who are doing extremely well, who are affluent, with whom I coach, that say that they're afraid to get married because they think that if I get married, this person might take me for all I'm worth and try to split all my assets in half. And so what I tell them is you can protect yourself by putting your assets in trust before you get married. Is that correct?
Absolutely. Now, it's interesting that you brought that up, but I get individuals almost on a daily basis. They either want to talk about a prenuptial agreement or what are my options? Especially the women. What are my options? I've learned that,
That's
you
boss.
know, there's some options for me to protect myself if the relationship doesn't work.
Right.
And the number one question I ask, okay, so I ask them all the time, I have fun with it. Are you in love? Well, yeah, I'm in love. Okay, is the gentleman you're dating and you call your fiance, is he in love with you? Oh yes, he's in love with me.
Hmm.
How do you feel about the marriage, the potential marriage? Do you believe it's going to work? Well, yeah, but we know things happen. This is not my first time. So, and when I got married the first time, I just, we just thought we'd be married and grow old together.
That's true.
But now this time, I'm trying to protect myself.
Hmm.
Okay. Well, ladies, if you listen to me, and fellas, don't get mad at me. I'm really for the fellas, but we got to protect the ladies. Now, if you get married and you do the lady wrong, the woman wrong, well, she needs to take all your stuff from you. So you just need to do the right thing. But ladies, I'll tell you this: before you get married, you got to put your affairs in order, put a trust in place. Especially some of you that have a nice home, and you may say to the potential husband, "Well, honey, you don't need to buy a home. You can just come and live with me." And he's already said to you, "I'll pay the mortgage, I'll pay the taxes, I'll do everything." Okay, that's a good thing for you. Now, you put your trust in place, and you don't even talk about it. You don't even talk about it because if I'm the man and I'm dating you, my desire is to marry you and take care of you. Well, I don't want to know I don't want to know anything about your stuff. Okay, I don't want what you have. That's your stuff. Now, but we know a lot of men will probably choose someone that's, aside from being attractive and all that good stuff, someone who's maybe doing okay. They have some assets, they have some means, and they're not coming to me as looking for payments, looking for me to just take care and pay expenses
Yeah.
and cover bad debt. So, ladies or gentlemen, ladies and gentlemen, put your affairs in order, put a trust in place, put all your assets in the trust. When you get married to the woman, gentlemen, you take care of her, you do what you're supposed to do. But God forbid if something goes south and you decide, or you all decide you're going to move on, and she start going through the process with a divorce attorney, and she's like, well, we got this house over here, we got this, we got that. He's got these investment accounts and all these different things. They both will be shocked when they do their little research and it's learned that, oh, well, his home is in a trust. And his investments in a trust. His vehicle's owned by a trust. So somebody said to me the other day that we need to think about calling this whole process once.
Hmm.
Own nothing, but control everything. Okay?
Mm-hmm.
Own nothing, but control everything. So now, the lady in the situation, getting ready to be single again, your assets will be intact. For the man, the same thing. Your assets will be intact. A prenuptial, I think, I'm opinionated like most people. A prenuptial is problematic. You're walking into the situation. Well, there's a high probability this is not going to work. We've got a prenuptial that we signed. You've got your copy, and I got my copy. So basically, you're in a contract until it comes to an end. Most contracts have some end date in it. So basically, that's what you've done. We know we'll have a good 5, 6 years out of this, and then we're ready to move on and do something different. Okay. So I wouldn't encourage prenuptials unless two individuals come and say, this is what we want. But I definitely support putting a trust in place.
Okay.
But once you put the trust in place, it's not a discussion to be had with your fiance or whomever. You know, you got most couples today getting married, most unions, in my opinion, are blended situations.
Yeah.
Not where the individuals were just married before, but they have children from previous relationships. So if you have a child, he has a child, or you don't, and he has or she has, that's still a blended situation.
Yes.
That's a blended union because they're individuals that's not from the marital union. Okay, so in the case where they are adults, when I say adults, more middle-aged, mature, 40s, late 40s, 50s, it behooves either of you or each of you to put a trust in place. I want my assets to go to my children, and your assets can go to your children. Whatever we amass together, that becomes marital assets. That now stays within the union. And if there are any children that comes from this union, they benefit from these items. Okay, so it's definitely a conversation.
Yes. And I feel like, Scott, I feel like if a person's not willing to have this type of conversation with you about estate planning and what happens, with your assets. Now, I think if they're not willing to have this discussion as adults, I think that's a red flag that this person may either need some counseling or may not be a good match for you, because this is very serious when it comes to how your assets should be divided. I don't believe in playing around with your assets, your wealth that's going to be passed down to your posterity. So like you spoke about being proactive, we have to be proactive and choose a mate that will be in alignment with our goal to build generational wealth and to protect your assets. What do you think about that?
Well, I would say if you're 45 years old, you're 40 years old, you've been married before, you have children, the woman to be has children, you must have a conversation.
Okay.
She's got her house that she's residing in now. He has his house that he's living in now.
Yes.
And you guys decide to be married within a few months. Okay. You must have that conversation about some estate planning. If it's me, I can tell you how I feel about it. If it's me, I'm going to tell the lady to be that assets that I have today will go to my children if something happened to me. Now, once we get married, we buy a family home, then that belongs to us. Okay. In the event of something happened to me, that home, you can reside in that home. That's for you. But you have children, you have your house. I don't need your stuff if something happened to you. Put something in place for those assets to go to your children. Okay. I think that says a lot about the individuals who are bold enough to do that,
Yes.
but it's also the right thing to do.
Yes.
Okay. It's the right thing to do. I know individuals, we're human, so we tend to look at what the person brings to the table. And we tend to want to marry because of some of the benefits we may receive.
Yes.
Not just the nice camaraderie in the relationship, the companionship, but the stuff that can be provided. That's fine. But there are tons of mistakes that's made when planning to become a blended family.
Yes.
Okay. Individuals do not plan. So if you're listening to me or you're watching me and you have a friend, a brother, a sister, could be your mom or dad. Everybody want to be with somebody. They plan to marry and their affairs are not in order. You've got to have a real conversation. You've got to have a heart-to-heart conversation. If it's your dad that's been used to delegating authority to you and now you're a mature adult, you're 30 years old, your dad is 70 or 80, and he's found somebody that's 50 years old, you got to, hey, Dad, let's talk.
Yeah.
You can't dictate to your dad, but you got to sit down and talk to him. Give him some advice. The same with your mom. Give her advice. Put things in place to ensure who you would like to receive your assets well. And when you're entering these unions, it is very important to do so.
I agree. I have an uncle that got married later on in life and married a nice fresh young woman, beautiful. He fell in love hard. I mean, she's gorgeous. I can get it. But of course, his children were angry. He told them, don't worry about, and he was sickly. So we're like, why would you marry this young, fresh young thing? It makes sense on one hand because she gave him life, right? But he only had a few years to live. He was so in love that he did not put his affairs in order. I mean, he had won cases. He had gotten money from some type of accident that he had. He had cars. He had homes. He was doing so well. So we're looking at it like this woman is a gold digger. She knows she's gonna be straight. He told us to mind our business, that he had it all to, everything in order. Well, when he passed away, he did not have his affairs in order, and he just assumed his wife would do the right thing and distribute the assets. Well, when he passed, she did not give the children anything. I think they might have gotten like a jersey or things that, I guess it had sentimental value, but they didn't get any of that wealth. And I don't want to say it destroyed the family, but he had a lot of children, and they fought against each other. Now they're angry with the wife. And everybody has an opinion. Everybody's choosing sides, who to agree with. And it's just not a good thing if you don't have your affairs in order. So I appreciate you saying that.
Well, one of the number one mistakes that's made when planning to become a blended family is believing that the surviving spouse is going to do the right thing. Okay? You have to put things in place. And the mistake that the children in the blended situation, even when they're adult children that may not reside with the couple, they have such animosity against a spouse that they never take the time to build a relationship. And in some cases, there's no respect. And you expect, or you think that your 85-year-old father, 50-year-old wife, or 40-year-old wife is going to do something special for you? Absolutely not. So it just behooves the individuals in the situation to kind of forge a relationship with the family members from the previous situation. We've got to talk, we've got to communicate, but you can't go out holding. I know for many of us, if our dad has some assets and he's, say, just 70 years old, 75 years old, he's still in good shape. He's still fairly young, but he goes and finds a lady that's about 35, 40 years old.
Yeah.
You have a problem with that. Because you like that, this lady's gonna, she's gonna drain you and drain all the juice out of you and then have a nice funeral. Okay? She might give you about 5 good years, you'll be happy. You might die with a smile on your face.
He will.
But what about all the stuff you have? What about my inheritance? Well, I want to get a little something, Dad, so you've got to talk to your family members and encourage them to put something in place. Now, we know there's something called an addendum or the AB trust. Okay, so God forbid, your father, usually this is a problem. It usually becomes a problem when the man marries some young thing. A lot of women tend to be reserved. Some of them don't even remarry, especially when they're up in that age. Yeah. But you got a dad who's, say, 75 years old. His wife of 50 years past. And after a year, dad's dating somebody, and now he wants to get married. But your dad has a trust in place. So now you've got to go and talk to your father and say, Dad, you've got to fix this. You've got to add a B section to the trust. Okay, we need now this to be an AB trust. Well, what do you mean, son? What you want me to do? Okay, Dad, so if something happened to you, you say you plan to get married. If something happened to you, well, because he has to do this now before he gets married. If he moved the new wife into the house, and then try to plan after the fact, unless he agrees to sign off on something, that house is going to be hers upon his death. 9 times out of 10, he's going to die before. It's just the way things work. So Dad has to amend the trust, put the AB trust in place prior to death. Okay? And he may have language in that trust that says, the son is already asking, what do you want to happen to the house if something should happen to you? Well, son, well, I want you all to get the house. Well, dad, to ensure that that's going to happen, you've got to fix it. You got to put it in the trust. So what the trust should say, upon my death, my spouse of 2 years, 3 years, 5 years can remain in this house for 4 years, 5 years, or until her passing, as long as she does not cohabitate. She does not bring a man and even spend one night. I wouldn't even give her one night. If the man spend one night, you got to go.
Mhm.
Now, some may say that's even harsh. Now, if I'm advising my father or if I'm his counselor, if I'm acting as his lawyer, and I'm going to say, Dad, okay, say for instance, your wife's 55 years old. She's got a house. She's got whatever. Okay, Dad, give her 2 years to get her stuff together, then she can go back to her house. After 2 years, she's got to go. That's an individual conversation, and that's based on how you feel about your situation. The key is, though, you got to plan. Now, we know Zoom has opened the world to us. It's made things really, the world has become smaller because of
Yes.
Zoom
Yes.
and other mediums. So conversations can be had night and day at a click of a button. So you need to talk to someone where you live. You can talk to me. You can talk to anybody you want to talk to. You can talk to Dr. Kia. So the key is don't just think about it. Don't just pray about it. Put action behind it and put something in place.
Yes. Because the scripture says a wise man leaves an inheritance to his children's children. And the rest of that scripture says, and the wealth of the wicked is laid up for the righteous. But I want to focus on the part that says a wise man or a wise woman leaves an inheritance for their children's children. When you talk about creating or protecting generational wealth, you have to be proactive about that, correct? You need to make sure that you're doing the wise thing.
Absolutely.
Hold on.
So many may say, well, this is a typical scenario. You've got a gentleman that's a father that's about 50 years old. He's got a nominal job, and he would say, man, Mr. Hall, man, I make about $55,000 a year. I don't have a lot, but I got a house. I got a little retirement I've been saving. I got a little investments, but I don't have much to leave to my kids. Well, you can change that. And for especially some of our older family members, grandparents, they all were trying to buy some life insurance, little debit insurance policies. Now, that's kind of played out today. Now, believe it or not, in some communities, poverty-stricken type communities, it still exists. The insurance agent still knocks on the door and collects a few dollars a week for the policy. Okay, so now we want to change the legacy of our family, the trajectory of our children's lives in the future. But you don't have $500,000 to leave in a lump sum. Okay, what you need to do, the $500 a month you want to save for your children, take that and maybe even add some to it and buy the largest life insurance policy money can buy. Okay, so the way you change your children's lives,
Hold on.
when you don't have a lump of money to just buy life insurance.
My life insurance. Okay. And then you can put that
Yeah,
in the
buy life insurance. So, and when I say buy life insurance, buy $1 million policy, a permanent insurance policy.
okay.
Put that policy in a trust for your children. Create a legacy. Now, the good thing in doing it that way, you get to decide, you get to say what you want to happen to the proceeds from the life insurance policy. Because you're not putting the beneficiaries' names or the ones you want to receive the proceeds from the policy on the application. You're making the trust the owner of the policy and the beneficiary of the policy. Therefore, when something happens, you've got language, the proceeds will be paid to the trust. But you've got a language in the trust that says who the beneficiaries are, how the proceeds will be distributed over a year, 2 years, 3 years, 4 years, or 5 years. You get to control that. Now, I know Mrs. Dr. Kia quoted the scripture about a good father leaving an inheritance to his children's children. That's a big deal. That is a big deal. And we can perpetuate that for generations to come. But when you don't have the means to do it in a lump sum, think life insurance. That's all it is.
I appreciate you explaining this in detail because a lot of us have not had access to this type of information. We just didn't know, we didn't hear about it. We thought estate planning was for extremely wealthy people. We even thought that acquiring wealth or planning ahead was something that other people did, rich people, smart people,
Hmm.
people that came from money. But no, this is something that we all need to do. Having said that, Mr. Hall, I have one final question for you, and that is, I've heard how a trust can benefit us and our families upon our death. But is there any way that having a trust in place could benefit us or our families while we're alive, while we're living?
Absolutely, absolutely. One of the immediate things that benefits you during your lifetime is the fact that one, you have anonymity on certain things. You've got protection. You've got asset protection.
Okay.
Um, and we know this is a problem that I deal with on a regular basis. Most of us, at some point during our lifetime, may need a nursing home, an
Mhm.
assisted living facility, and we may not have long-term care. And for many of us, we won't have the ability to pay. So when you begin the process of estate planning, that's something that's discussed and it must be taken into consideration. Now, I would typically encourage someone in their early 50s to purchase a long-term care policy. But
Mhm.
if you don't do that, you have that. One of the huge benefits of having a trust in place is protecting the family home. So when you put your home in the trust, you now must live, by the way, 5 years um, after the trust has been put in place to avoid that look back period when you go to the nursing home, you needed some assistance from the government. That's a major, major benefit. Okay, so when you go to the nursing home, you're getting ready to put your loved one in, and they say, "Well, we need to complete a financial profile,
Mhm.
an analysis of what you have, where are your assets." Okay, the home that you live in, who owned the home? Well, I don't own the home. The home is owned by a trust. Okay,
Mhm.
that's a huge relief right there to the family because most individuals want the home to go to their children. But putting the assets in the trust, it gives you a peace of mind and knowing during your entire lifetime that if something happened to me, this home is going where it should go.
Mhm.
Also, your assets in the account, your savings, your checking account, those assets, there's no one individual can run to the bank with your death certificate and some information trying to get those proceeds.
Mhm.
Those proceeds will be paid to the trust. Okay, so you have privacy during your lifetime. That's a big deal. Many of us, we like privacy.
Yes.
You've got protection against frivolous lawsuits and things like that.
Okay.
Okay, you've got an assurance in knowing that if something happened, my ass is going to go to where they should go.
Mhm.
Okay, so those are some of the benefits you can get in life. And in debt, of course, you can be dead and gone 20 years, 10 years, but you're still controlling from the grave. Okay, the trust is still your language in the trust upon death. It becomes testamentary.
Mhm.
It cannot be changed for anything. Okay, the only way a trust will be set aside if you can prove one of three things. Okay, legality. It was never a legal document from its inception. There might have been an issue with capacity.
Mhm.
Individuals were not in their right mind. They had some terminal illness
Mhm.
or duress. Someone threatened you to sign these documents or we're going to harm you. If you can't prove one of those, the trust will not be set aside. But
Mhm.
your language in the trust rules today. 5, 10, 15 years down the road, your language is still there. You have a perpetuating trust where individuals that born into your family, your grandkids, great great grandkids, they all benefit from the trust when you talk about creating a legacy.
You talked a bit about being in the private. So one thing about anonymity I wanted to ask you about is, other people don't know what you have. So having said that, I wondered, are you saying that if you have, say you have a car and the car is in a trust, can a person still sue you? Can a person sue you as an individual if your car belongs to the trust?
Well, they're going to sue the owner of the vehicle. Now they can
Oh,
sue you as well, but normally they're going to go after the owner of the vehicle because you would have you would have auto insurance,
yes.
but they're going to go after the trust.
Oh, they
The
are.
trust
Okay.
owns the vehicle.
Okay.
So keep in mind, estate planning with our firm, your exposure will be limited because the trust that you have your vehicles in is going to be limited just for that.
Okay. Okay.
Okay, so therefore, I'm limiting and reducing my exposure. But all of my fancy assets, my diamond rings, my gun collection, my jewelry, my expensive properties in various
Mhm.
cities or state or even countries, investment accounts, stocks, bonds. They're in a separate trust that
Okay.
doesn't move around on wheels. Okay,
Okay.
so for many of us, when you lump all of your assets into a trust, and that trust is now valued $4 or $5 million, and your vehicles are in that trust, and you're driving these vehicles down the road, and you hit, say, a pregnant lady, that's bad itself, and it's your fault. But now, not only did you injure the pregnant lady, now she loses the child, the unborn child. So she is going to sue the owner of the vehicle and the owner of the vehicle. In this case, if it's owned by your sophisticated, heavy loaded trust, then
Mm,
she's that's all exposed. She has
mm,
access to that. But if the vehicle is in a separate trust, where the trust may only own another two or three vehicles, and those vehicles are worth $60,000, that's the maximum that she's exposed to. If
awesome.
she sue you personally, you own nothing based
Mm,
on how you structure your estate plan. So it's
okay.
definitely something to think about.
Okay. So this trust can hold stocks and bonds, I heard you say. You could put all your assets in. Can I assume that you can put gold, your
Absolutely, you can
currency, okay.
put your gold, your silver, your bullion, whatever coins you have, anything that you own can be transferred to the trust as long as it's legal.
Okay.
Now, what makes when I mentioned legality in terms of putting a trust in place, what makes a trust not a legal document, one, is it was net funded. Now, so when you put the trust in place, you must fund the trust. You must put something of value in the trust, an
Mm,
investment, a house, a car, whatever it is.
okay.
Um, but when the trust becomes a problem with legality, when there's a problem with legality as it relates to the trust, you cannot put a contract in the trust that says, well, I've got these dogs, but no one can take care of them like I can.
Mm,
So I don't want my dogs to suffer. So if something happened to me when I die, I want my son John to just take a 22 and just shoot every dog in the head, just one shot. That's illegal. So if
mm,
you have that contract attached to your trust, that nullifies your entire document. Your entire trust is deemed not a legal document. Okay, so you cannot have an illegal document or contract in your trust. All
mm,
right.
okay.
So that's the issue there with legality.
Okay. Can you have a business and put the business in the trust and have the trust to pay out your employees?
Well, your interest can be put in the trust, but the business will operate as its own entity, and a trust can be set up within a business. Of course, you can do that.
Okay. Okay. Well, you have taken a lot of your time to explain this in detail to us, and I wholeheartedly appreciate it. This is something that we need to know, especially in our community where it hasn't been shared, this information. We just didn't know the information, I think. I don't think anybody's been trying to keep it away from us. We just didn't know it. So before we close, I'd like to know how is it that we can get in contact with you if we know we want to move forward in this process? What should we do? What's in the
Well, the company is called Scrijoven Trust Planning Company. We're located in Jacksonville, Florida, with offices in Boca Raton, Florida, and in the Bahamas.
Okay.
The telephone number here at the main office is 904 544 3800. That's 904 544 3800. If someone wants to contact me directly, that's 904 228 5067. 904 228 5067.
And what about the
And
website?
I'd like to thank you, Dr. Kia, for having me on.
You're welcome.
Oh, I'm sorry. Yes, we do have a website. The website is www.scrijoventrustplanning.com. And I'll spell that for you. Scrijoven, Scrijovan. Scrijoven. Trust, Trust, planning, Planning.com.
Thank you so much. Do you have any final words for us? Something that you want to leave us with?
Well, first of all, I'd like to thank you for having me on. I started to say that earlier.
My
I'd like to
pleasure.
thank you for having me on. I feel honored when individuals like yourselves approach us and want us to share some of the things that we do in the estate planning arena. Um, and for those of you that's out there listening, you've got to put something in place. Understand this. Don't let cost be a deterrent. Don't let it be an issue. Don't procrastinate. When you want to know that you know that you know that you know, your assets going to go to who you desire to receive them. Remember this: protection and risk and uncertainty are free. Protection and predictability comes at a price.
Can you
Okay?
say that? Can you say that one more
Risk and
time? Because
uncertainty are free. Risk and uncertainty are free. Protection and predictability comes at a price.
Hmm,
Okay, so when you want to know that you know that you know, you just pay for it. We pay for everything else that we want in life. Okay, let's make sure that what we worked hard to amass for many years, is going to go where we wanted to upon death. Okay, I know we want to live a long time, we want to live forever, and people don't like to talk about death because it's morbid. Okay, but it's inevitable. So let's do the right thing.
absolutely. Thank you so much, Mr. Scott Hall. I love you. I love your family. I love your business. I love what you're doing for the community, not just the so-called Black community, but you're doing this for all humanity. And that's something that we talk about on this channel is, yes, that we're all one family, and it is our responsibility to help everybody because everything is connected. We're all part of the one. We have come from one creative source, and everything that I do impacts somebody else, regardless of a community or a color or something like that. So I appreciate the contribution that you're making to humanity. I really appreciate that.
Thank
Family,
you.
oh, absolutely, my pleasure. Family, I know, I trust that we've said something to raise your vibrations, to inform you and educate you so that you can have all the tools that you need to create the most magnificent, glorious life that you desire and deserve. Having said that, make sure you like and subscribe to the channel. Share this information, share this video. This is important information. And please patronize Skradrovan Trust Company because this is a valuable company that will assist you as you move into the future and protect your family. Also, keep in mind, if you like to buy precious metals, we need for you to contact our good friend, Andy Sheckman, the CEO of Miles Franklin Company. You all know that he's been in business for 30 plus years. He has an A plus rating with the Better Business Bureau and not had one complaint. Go ahead and make that call. Contact Andy at info@milesfranklin.com and ask him for a list of his inventory as well as his prices, and let him know that your friend, Dr. Kia Pruitt, referred you, and you will get the best prices in the industry. Also, when you contact Skradrovan Trust and you let them know that Dr. Kia Pruitt referred to family, you're going to get the best prices in the industry. He already told you our fees are nominal. So that means that, you might find some lawyers that will do this work for you, but not somebody that's been in the business a long time and someone who is really, really heartfelt and has a desire to make sure that you are protected. So when you contact Skradrovan, let them know that Dr. Kia Pruitt referred you. I love you, family. You mean so much to me. Go out and make this a great day. Mwah. Mr. Hall, I'm going to call you after this, okay? I know you're busy, but I want to call you.
All right, you take care.
All right. Thank you so much. Peace.
All righty. Bye bye.
Bye-bye.